I am renting in Chicago. Does Chicago Landlord Tenant Law apply to me?
The Chicago Residential Landlord Tenant Ordinance says it applies to all dwelling units in the city. However, there are some exceptions.
The ordinance does not apply to bed and breakfasts or hotel stays for 31 days or less, or to stays at monasteries or convents.
College dorms, to hospitals, homes for the elderly, or any place where you, the tenant, do work for the landlord instead of paying money for rent. The most frequent exclusion that tenants run into is for owner-occupied buildings that are also 6 or fewer units. For example, if you rent a single-family home in the city, it is covered by the ordinance because it's not occupied by the owner. And even if the owner lives just next door in a different building, you're still protected by the ordinance.
If you live in a 2-unit building, it will also be covered by the ordinance, unless the owner also lives in the same building. If you're renting in a 3-unit building, you'll be protected by the ordinance, again, unless the owner lives there.
Or if each of the units is actually a separate townhouse with separate ownership and separate tax numbers and address, you'll still be protected by the ordinance even if the landlord lives under the same roof. If you rented a bigger building that still has 6 units or 5 units, it's covered by the ordinance again, unless the owner lives there with you. If you rented any place that has more than 6 units, you're going to be protected by the ordinance, even if the owner lives in the same building. That goes for condo units in big buildings or apartments in big buildings. Some unusual situations include if you rent in a coach house or a separate garage behind the main house on the same piece of property. If the landlord owner lives in the main house, even though they're under separate roofs and not the same building, you will not be protected by the ordinance. If you rent in a building that's got apartments above a commercial unit like a restaurant or a bar or some other business, even though the owner technically occupies the bottom with their business, it's probably not considered an owner-occupied building because the landlord owner does not live there.
So remember, the ordinance applies to almost every unit in Chicago unless the building is both 6 or fewer units and owner-occupied.